Let's see if I'm unmuted.
You're not muted, Mr. Moore.
Okay, thank you. Thank you, Judge.
Judge, this is Terry. Can you hear that echo or that?
I'm unmuted.
You're not muted, Mr. Moore.
Okay, thank you. Thank you, Judge.
Can you hear a sound that's like bouncing around, Judge?
Yeah, it's an electronic sound of some kind.
Of course, it's not happening now.
I don't know where about that one. Lost my connection with him, looks like. But I can still hear him. I just can't see him.
Everything good?
There's Mr. Vasquez.
Yes,
You can hear us?
I can. Yes, sir.
Okay, all right, sir.
Thank you. Long, we have somebody else joining in, F. Long Law.
Judge, I started to join in on my other computer because I have a potential witness and I don't know, she's in the room with me. I don't know how you want to handle that.
Today.
If you don't have a problem with her being in the room with me while we're doing this, then I'll just let her stay in here and she can work off of mine as well.
Yeah, I'm fine with it as long as Mr. Kamenar is. We've got some other rules that are coming out regarding
How to do that.
how to do all this, but
Judge,
right
can
now.
If necessary, I can set her up in a different room.
Judge, can I say something?
Yes, ma'am.
Last week, Ms. Drake had a witness in the room next to her on the same computer, and it didn't work. So when the question and answering starts, can we just verify that I'm gonna be able to hear the beginning
We
and
will.
end?
Absolutely.
Thank you.
Yes, okay, thank you.
You just need Mr. Kamenar.
Yeah, you're fine.
Judge, would you like for me to call the DA's office?
If you don't mind, I was about to send a text, but if you can call them, it'd be great.
Do you
The
know?
secretary, and she said she would go find Mr. Kavanaugh.
No, okay, it would have to be somewhere. He's not here. Okay.
Is Ben on yet?
No, ma'am. Terry called him.
Look in the trash and spam. If you travel off the thing, it rings. This rings.
Mhm.
And Ben's not getting his.
Okay. He needs to hit fresh a few times. Let's see. Mhm. Ben Kavanaugh.
I get something out of 909. I didn't. Just like this. Good to know.
Yeah, I'm trying to make. Technology's great when it works, Judge.
Yeah, I'm sorry. We're waiting on. Mr.
No, it's
Kavanaugh.
okay. It's okay.
We sent him 2 emails now. So hopefully he'll be in soon.
Judge, I'm going to step out and talk to Chris. He does know a little bit about the Zoom hearing.
Okay.
I think he helps them sometimes.
Y'all send me, get back. Get laptop.
I get back in just as the judge leaves.
I'll send it back.
For some reason, I had to reconnect, Judge.
That's okay.
Hey, Pam, this is Terry.
He's,
Judge Pam is talking to Ben now, and she's had him move to the DA laptop, so give me just a second.
thank you.
Judge,
Yes, ma'am.
the DA's laptop was turned off, so they're waiting for it to reboot, and then they're going to move it into Ben's office because that's where all of his information is.
Okay.
Thank you.
Kamenar, can you unmute your microphone, please?
Yes, Judge, I normally leave it on mute and then unmute to speak so it doesn't catch any background noise.
Okay. Need to check and make sure we've got good audio. I believe we've got everybody present. Ms. Spangler, are you present with us?
I am, Judge.
All right, before we get started, I need to remind everyone, pursuant to the Texas Open Courts provisions, this Zoom hearing is a little bit different. It is being broadcast live on the court's YouTube channel. We're required to do that. So please understand that these are made public in some way. So, you know, I know in some of our other cases involving children and other sensitive issues that may allow us to deviate from that open courts provision. This one's different and it is being broadcast live. So with that being said, all parties being present, court is going to call cause numbers H2O-464 and 465. These are writs filed on behalf of ADL Vasquez. Is that correct, Mr. Long?
It is correct, Judge. I think he's also, the jail may have him listed as Adiel Vasquez Pablo, I'm sorry.
Okay.
But I believe he goes by Vasquez.
All right. Now, before we go any further, I need to remind everyone that we are complying with all the guidance handed down by various federal and state agencies, the Office of Court Administration, Court of Criminal Appeals, and the Texas Supreme Court. Pursuant to their most recent guidance, we are to conduct all these hearings by remote proceeding. I did ask Mr. Long if there were any confrontation objections that he might have, and that was asked in an earlier email, and I understood Mr. Long did not have any confrontation objection and agreed to take this matter up by Zoom. The guidance that we did receive doesn't speak to the state of Texas having any objections to having these matters by way of Zoom. So respectfully, that question was not posed to the state. Now, the court is making a recording of this. Court records all of its Zoom proceedings. Those are held locally on the court's own computer. However, Ms. Spangler, the court reporter for the 6th Judicial District, is transcribing this, and her record will be the official record of this proceeding. Now, again, I understand these are writs filed under Article 17.151. Is that correct, Mr. Long?
That's correct, Your Honor.
Both sides ready?
We're ready, Judge.
Your Honor, the state has not seen a copy of those writs. I have inquired with Mr. Young, who I believe those would have been sent to, and he has not received a copy. I have searched Odyssey under both the magistration cause numbers as well as what would presumptively be the writ cause numbers, and finally also under the defendant's name, and have not found a copy in Odyssey anywhere. So the state is at a disadvantage here, not having seen what is actually in the writs. Presumably, with it being a 17.151 writ, it's the 90-day indictment issue, but I don't know what else may or may not be in there.
We checked this morning and it appeared that the clerk's office still showed this as pending, or I'm not sure that it had been accepted. So that may be why Ben hasn't received a copy of it.
Give me a second.
Again, I know it's not the same as reading it, but I can tell you it's a bare bones allegation. Alleges that he's been in jail more than 90 days for the 2 charges. So, but we'll try to get you a copy.
Okay, I'd appreciate that.
I'm about to address that right quick. It is still hung up in the queue. If you don't hit certain buttons, it doesn't proceed on. We had already said it, so. Give me a second, Mr. Kamenar. All right, if you'll look in your chat box. The PDF of the writ should be there.
Okay, I see it. Thank you, Judge.
You're welcome. Marvels of modern technology. However, it doesn't always work that way. So, okay. Give Mr. Kamenar time to scroll through it. And it is, Mr. Kamenar, the court has reviewed that and does take judicial notice of the files. What I gather from the application is that he was arrested for the offenses of murder and deadly conduct, discharge of a firearm back in August of 2020. He has been continuously confined, and the bonds are set currently in the sum of $100,000 on the murder charge and $20,000 on the deadly conduct charge. So let me ask now, are both sides ready to go forward?
We're ready, Your Honor.
It's ready, Your Honor.
All right. Mr. Long, it's your application. I understand part of the burden shifts back to the state, but if you want to, just for record purposes, make your position known.
Yes, Your Honor. I would, for purposes of calling a witness, I would call Judith Vasquez, who is here in the office with me. That's sister-in-law of the defendant.
All right, Ms. Vasquez, could I get you to raise your right hand? Regarding the testimony you're about to give, do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay. Would you state your name for the record for us, please, ma'am?
Judith Vasquez?
And Judge, I know the court reporter had indicated she might have an issue hearing. I just want to check and make sure she can hear both of us.
I can, Judge.
Okay. And how are you related to Adiel Vasquez?
Adele is my brother-in-law.
Okay, and is that Mr. Vasquez that appears in the orange and white jumpsuit with a face mask on?
Yes, it is.
To your knowledge, has Mr. Vasquez been in the Lamar County Jail since he was arrested back in August, I believe the early morning hours of August the 2nd or late hours of August the 1st of 2020?
Yes.
Okay. Are you aware that his bond is set currently at $100,000 in a charge pending in the Justice Court on a offense alleging murder?
Yes.
And are you aware that his bond is set at $20,000 on a charge of deadly conduct involving a discharge of a firearm?
Yes.
Okay. To your knowledge, have you or anyone on Mr. Vasquez's behalf or himself been able to post those bonds?
No.
Okay. Is it your understanding that it would require you to pay a premium of approximately 10% of the bond amounts for you to be able to make those bonds?
That's correct. Yes.
Okay. To your knowledge, does Mr. Vasquez have property of his own or resources that would enable him to post bonds in the amount of $120,000 in total?
No.
Are you aware of anyone that would have the ability to post those bonds for him, that is family members or friends?
No,
To your knowledge, and has Mr. Vasquez, prior to this arrest, ever been arrested either in Lamar County or, to your knowledge, anywhere in the state of Texas or any other location?
no,
Okay. And you've known Mr. Vasquez for approximately 5 years?
yes,
Prior to his arrest, was Mr. Vasquez employed?
yes,
If the court were to reduce his bond to either a personal recognizance bond, or he was able to post a bond and be released, would he be able to reside with you?
yes,
And do you reside in Lamar County, Texas?
I do, yes,
You're currently married to his brother, is that correct?
that's correct.
If the court were to place requirements on Mr. Vasquez of a curfew or some type of restriction on his ability to travel or move about, would you be able to assist and provide supervision for him in that regard?
Yes,
If the court were to require some type of monitoring, would you be able to assist through family or church or friends and be able to afford to pay for some type of ankle bracelet or GPS monitoring?
yes,
On Mr. Vasquez's behalf, are you asking the court to reduce his bonds to a personal recognizance bond so that he might be able to be released prior to his trial?
yes,
Are you aware, or do you have any knowledge that he has been indicted at this time?
no,
And at this time, Your Honor, I'd ask the court to take judicial notice that there has been no indictment returned in the 6th District Court charging Mr. Vasquez with either of these offenses.
Court will take judicial notice of that fact. I'll get confirmation though from Mr. Kamenar. Is that correct?
That is correct, Your Honor.
Thank you.
If the court were to set a surety bond, ma'am, would Mr. Vasquez or you on his behalf, do you believe that y'all could post a bond in the amount of approximately $20,000?
I believe so.
And then that would be in total, correct?
Yes, the total.
I have no further questions, Your Honor, of this witness.
Mr. Kamenar.
Thank you, Judge. Ms. Vasquez, are you aware that Mr. Vasquez currently has an Immigration and Customs Enforcement detainer?
No,
Did you know that someone with such a detainer, when they post a bond on their criminal charges, are then transferred to ICE's custody?
no,
So you didn't know that if the bonds were reduced and posted, that he would not be coming back to your residence?
no, I didn't know that.
Pass the witness.
Any other questions, Mr. Long?
No, Your Honor.
Any other witnesses?
No, sir.
Okay. Mr. Kamenar, state have any witnesses?
No witnesses, Your Honor. I will ask the court to take judicial notice of the governor's executive order suspending Article 17.151 of the Texas Code of Criminal Procedure, as well as the Supreme Court and Court of Criminal Appeals' emergency orders authorizing trial courts to suspend or modify any limitations or deadlines contained in statute. Other than that, the state has nothing further.
Court will take judicial notice of those orders in the, not only from the governor, but also the Supreme Court. I believe it's executive order number 13. That was the governor's order, to be specific, that suspended the deadlines under Article 17.151 of the Code of Criminal Procedure. All right, both sides rest and close.
I would just, Your Honor, I know I sent the court a case that was out of the Third Court of Appeals, Third District, Austin, and I would refer the court to that particular decision by that court. It's number 03-20-003V2-CR, ex parte Michael Tucker, in which that court, when it reviewed this matter, a 17151 writ found that the authorities that have been cited for extending the deadline did not apply, and that the 90-day rule under 17.151 still was in force. And I believe I sent a copy of that to the district attorney's office as well.
Mr. Kamenar, do you have any comment regarding that particular case?
Well, first, Your Honor, I have not received a copy of that. I saw the email chain where that was apparently provided to Mr. Young and asked him about that, but he did not have that attached, so I'm not sure what happened there. I would point out that this court is not within the 3rd Appellate District, and at best that is persuasive authority. The Supreme Court's orders are specific that the trial courts may suspend those deadlines subject to constitutional limitations. Article 17.151 is a creation purely of statute. It is not contained within the Texas Constitution, and therefore is within the trial court's authority to suspend or modify that deadline under Supreme Court's orders, or to regard the entire article as having been suspended under the governor's executive order.
Well, I'll let you know, the court did review that case, and court respectfully is going to disagree with Mr. Long's interpretation of the ruling. The basis for that is on page 5, footnote 4. The Austin court specifically noted that the Austin DA did not, as a matter of fact, they disclaimed any reliance on the governor's executive order suspending Article 17.151. So this case, the Tucker case, has nothing to do with whether or not the governor had the authority to suspend those deadlines. Instead, it was talking about whether or not the trial court had the authority to suspend those deadlines, which they did. So it's on an entirely different level. And I would note that that was an Austin case and a Third Court of Appeals case, and they sometimes are going to disagree with the governor and his authority as to whether or not he had the right to suspend Article 17.151. So the defendants, like I said, the court respectfully disagrees with the defendant as to the applicability of the ex parte Michael Tucker case. Anything
If
further?
I could ask just one other question at this point, Judge. At this point, the state would be not ready for trial, correct?
That's correct. We can't announce ready until we have an indictment returned.
And that does, Mr. Long, anything else you need to address? Clearly, I want to make sure that that's right to make a good record.
Yes, I want to. Judge, just I guess as part, I understand the court's ruling, just as part of my argument.
Well, I haven't ruled yet.
Oh, I understand. Okay.
But as far as the applicability of the case, okay.
I appreciate that. Is that the writ of habeas corpus is a writ of right and should never be suspended. And the emergency orders did not explicitly address grand juries, whether or not they could meet, and did not implicitly prohibit them from participating either by teleconference or video conference. I know that on occasions, and I think the court can take judicial notice that Lamar County has had grand juries during this time frame. And that
we'll take judicial notice of the fact that we have had a sitting grand jury each month during this time frame.
And that therefore the delay that has been caused to Mr. Vasquez is not because of some inability or lack of opportunity to present this matter to a grand jury. And so again, we would urge the court to grant our motion and set whatever restrictions the court might feel necessary as far as the bond conditions, but to reduce the bond and to set a bond in either an amount that could be made or a PR bond for Mr. Vasquez, and the actions of a federal court or federal authorities as to what they do or do not do with regard to Mr. Vasquez does not impact the application of this rule or the writ of habeas corpus.
Mr. Cameron, do you have anything you wish to add for the record? I'm trying to be as lenient as I can.
Your Honor, I'd just point out that the writ of habeas corpus has been neither suspended or abolished or anything else. The defendant has been able to bring that writ to the court. The court has heard the writ. The only thing that has been suspended or modified is what relief might be available pursuant to that. His right to file that writ and bring it to the court has been in full force this whole time.
And my only response to that is a right without a remedy is of no value.
Okay. Well, there being nothing further, let me just state that the court is going to deny the writs. I want to note that this reliance is primarily based upon the governor's emergency order suspending the deadlines. It's not always so much whether or not a grand jury can meet, but as you all know, there are other working parts to a criminal investigation that might produce evidence that would need to be presented to a grand jury. And in these pandemic times, some of those labs and experts and other testing facilities are somewhat behind, and that may play a role as well. Mr. Long, yes, you raised your hand.
Yes, Judge. Just in order to make sure that my record is complete, there's one additional thing I would like to point to the court. Yes, that the arrest and incarceration of Mr. Vasquez is not a court proceeding, which is what I believe the emergency orders apply to, deadlines. And so I would again urge the court to reconsider its decision based on that fact as well.
Okay. Well, I believe Article 17.151 was specifically mentioned in the governor's emergency order number 13, but your request is noted but denied. And again, the court is going to deny these applications. I also want to note that the amount of the bond currently set at $100,000, and for the murder charge, and $20,000 for the deadly conduct discharge of a firearm. Had the court moved to that, considering the circumstances and the assumptions that can be made from the ICE detainer, the court would have found those dollar amounts to be very fair and reasonable in terms of flight risk. So two-part analysis. If the courts above me ever need to know, I've denied it based on the governor's order, as well as the reasonableness of the bonds. Anything further? Mr. Long?
No, Your Honor.
Mr. Long, in all fairness, though, I'm going to tell you that the court will not penalize you if after another 60 to 90 days you wish to refile these motions. Okay, I sympathize with those that are being held in the jails and awaiting trial, and it's very difficult on everybody. So I know some judges would maybe look crosswise at you if you refiled, but this court will not. Okay.
Appreciate that, Judge.
All right. There being nothing further, this hearing is adjourned. Thank you all for your efforts.
Thank you, Judge.